So let's talk about some cases in which the courts have said, nah, I don't think so. That fitness for duty evaluation should never have been ordered. Now, Stewart versus Pearce is a landmark case. It goes back to 1973 in the Ninth Circuit. And this was during the Vietnam War when some faculty members were protesting. And Stewart was a little excessive in his protest for the war. And even the faculty senate thought that he was too far out there and they were concerned about his behavior. So he was told that he needed to have a psychological fitness for duty evaluation. And he filed for an injunction, and the court did in fact enjoin the university system from requiring a fitness for duty evaluation, finding that the requirement itself created a stigma, that there were no reasonable grounds for regarding Stewart as showing mental unfitness for the job, and that requiring it created a stigma or an unofficial branding of the plaintiff. Watts versus Alfred, this is a fire department case, and Watts is a fire captain and Alfred was the chief. Could have been the other way around, but one of them was the captain and one of them was the chief. And the captain had posted a denigratory cartoon that ridiculed the chief and posted it in the fire station where he was the captain on one of his shifts. And the chief got wind of it and told him to take it down. And those of you who work in fire departments, fire stations, know that on an A, B, or C shift, the fire captain in that station is God. And so you're not going to walk in and pull down a cartoon. You can order the captain to take it down. And the captain refused. So the chief said, fine, you're leaving that station. I'm transferring you to another. And by the way, I'm ordering you to submit to a fitness for duty evaluation. And so again, filed with the court to enjoin the compulsory evaluation, and the court enjoined both the fitness for duty evaluation and the transfer. Merillat versus Michigan State University. Merillat is a dispatcher working for the Public Safety Department of Michigan State University. Merillat's performance was fine. Merillat's problematic behavior that the chief used to justify the evaluation was that she had an affair with an African-American supervisor. So he figured that that must be grounds for questions about her psychological suitability. So he referred her for a fitness for duty evaluation. Michigan Court of Appeals held that the order was unlawful because it lacked a valid job-relevant basis. It didn't meet business necessity standard. In the case of Maplewood and Law Enforcement Labor Services, this is an arbitrator's ruling, but it was an interesting one because of the Maplewood's sole transgression was that he told a, you'll have to bleep this, Jim, later, but it's just what happened. Okay. He told the dispatcher on the air to fuck off. So the arbitrator, which happened to be Joe Daly, he's a law professor, some of you may have knowledge of him. He determined that the obscene language that was used by Maplewood did not justify an order that the, quote, expressive officer, unquote, should submit to a fitness evaluation. oh, I'm sure discipline would be appropriate. And of course, McGreal versus Ostra, we mentioned this in a different context yesterday. The court concluded that there was no valid order, meaning that there was no reasonable basis. But even if there were, the scope and, quote, republication of the data that was gathered, the information, personal information that was gathered in the course of the evaluation, exceeded the legal authority to provide it to the employer. Remember, this is one more case in which the court has determined that the examinee is a patient under the law, and that there's a doctor-patient relationship.